Hi, and welcome to episode 33 of Guest Safety Officer Lobby Group. Today, we're here to discuss a very important topic, and it's going to be introduced by our good friend, Trevel Henry from NFPS. We've also got Jim O'Dwyer with us as well from Aegis. Gary's here, obviously, and so am I. So, quick round, the thing. Lead off, please, Trevel. Who are you?
Yeah, good day, everybody. I'm Trevel. As Jim, my apologies, as he has already mentioned, I'm one of the co-directors at NFPS Limited, along with a guy called Ram Dandels. That's me.
Yeah, Jim.
Jim O'Dwyer from Aegis Protective Services, consultant trainer. Been doing it more than 20 years, and act as an expert witness on use of force.
Okay.
And I'm Gary Wright, 37 years in the industry. Most people know what I've done now, but I don't do cybersecurity at the moment.
And I'm Ian Fox, and I'm just very fortunate at this moment in time to be with three really good, competent, and knowledgeable people. Trevel, I'm going to sort of hand it straight over to you and sort of explain the post that you put up on LinkedIn earlier this week that prompted this discussion.
Yeah, no, thanks, Ian. I mean, it links back to the post, as you know, about defending the right to self-defense at work. And, whilst the headline itself is quite specific, but the text within the post itself gave the wider inference around not only self-defense, but people's duty of care to do the right thing in the workplace. It's not all about physical intervention, but when we say self-defense, people are going to naturally think something physical is involved, for example. So whilst the headline was about that, but the post got into the inference around, i.e. people being empowered to do the right thing. So they've got a duty of care, haven't they? I.e. in many, many aspects, just use that broader heading, they've got safeguarding issues depending where they work and young people. Yeah. So really what I was trying to get the point across, and I've had a few messages and phone calls from people. Again, we want to reinforce that point, don't we, for management, not all, but management to empower their staff, to feel confident to do the right thing. Because as we've discussed before, collectively and individually, just to say on a case-by-case basis, I'm just conscious, a little bit of time themselves. So unless we was discussing a specific case review, then quite rightly, but it was really that trigger around, a lot of training, let me use the example just as it just comes to my head. We talk about lots of things, don't we, around minimum force. But as we know, there's nowhere where it states around minimum force. No, that's what I'm trying to say, though, Jim. Exactly. It doesn't state anywhere legally. But the point I'm trying to come to, though, when those kind of messages are being put out in policies, then with respect, we're depowering staff, aren't we? Because the inference, not all, but the inference a lot of staff are taken away from, that policy, procedure, and/or training is whatever I do in that moment has got to be minimal. Yeah. And so rather than just go out professionally, do what you believe is right. Yeah. And that's the balance that I was trying to get to within the post. We want those clear messages, not some constraints or barriers put in there, just staying with the, whatever we do must be minimal in the circumstances. So that's really, I was just trying to put it out there as people read through the literature, then they see it was much wider inference than just self-defense, but hopefully the self-defense at work was a hook to get people to read the post, really.
Okay, Jim, what was, given what Trevel said and the post itself, what's your view on it? What's your take generally?
Well, I felt after reading Trevel's post that I was much better informed, but none the wiser. It's a huge subject, isn't it?
Mm-hmm.
And it needs to be refined down so that we can have a meaningful discussion about it. I mean, I'm aware that there's a real problem for a lot of security personnel if they use force against any of the clients, whether they're patients or retail customers. There's a strong chance that they're going to get dismissed or asked not to be put on the rota again at my venue. And obviously a lot of people, it's a terrible thing. I mean, I remember there was an EMAS I think he was a paramedic, but ambulance technician, and he at one point restrained a patient who was known to be violent, and the guy was going to try and throw a punch at him, and the guy twisted his arm up his back, and he reported it as he was, you know, supposed to, and as a result he got sacked. I think he took the trust to an employment tribunal, and I think they didn't, or the trust didn't respond in time, and so the case, he won the case, but then they appealed, and it appears that they won the case. So I don't know what to say, but I mean, his life was ruined. This is a guy that perfectly, you know, great career, really, helping people, and he lost his home and everything with the legal proceedings, and very depressed at the end of it. So I don't know, is that where we're going with it, or is it the right to walk away? You know, which in any event, in any self-defense situation, the law expects, or one of the first questions the courts would ask is, why didn't you walk away? Why didn't you, you know, distance yourself? Why did you keep going towards the person? Security people don't really have that excuse, if you like. So it's not a determining factor, but it's a factor that can be a determining factor in a situation where you're dealing with somebody who doesn't have to confront individuals.
Don't you think? Sorry, Jay, I just wanted to ask, and before I bring Gary in, is I just wanted to sort of ask there, and probably of you as well, Trevel, is we have two separate issues here. Do you have staff that have to go forward? Who says? Because in retail, you don't. I mean, that's the general message that we're getting out there at the moment, is that in retail, you don't. You step away, let them take to whatever. That is the general thing that's coming out at the moment. However, when you're in the social economy, and by the social economy, I mean places where you are outside of work, you may be going to a supermarket, you may be going out to enjoy yourself, whatever, the social economy, then the people employed to protect that space or create safe or civilized spaces, they are by and large expected to take action. So there's a dichotomy, as far as I can see, you know, in that diametrically opposed positions. I mean, Gary, you've worked in, Gary, you've worked in both the security side of things and in the nighttime economy. What's your 37-year view?
Well, what you've got here in is you've got you've got a number of things going on here. Firstly, let's look at retail security. Retail security badge, or the basic door supervisor, or the basic security badge, doesn't cover PI training. That's the first thing where your deal supervisor does. Now, if you're going to start talking about security working at that point, we are expected to go forward. But when you're looking at, i.e., not the security companies, but you're looking at the vendors or the shopkeepers or what have you, they have different policies in place. Like a lot of big organisations have this hands-off policy. So again, your self-defense is great when that works, but as Jim said, you know, you had a paramedic got hands-on with somebody, and suddenly the trust is going, "Oh no, you can't do that." But was it self-defense he did? Well, it wasn't self-defense he did. He acted appropriately what he thought was right. So when you've got policies and procedures which contradict each other, but where the law comes into play. Now, we spoke about section 44 of the Health and Safety Act, isn't it? The Health and Safety Workers Act.
Employment Rights Act.
Sorry?
Employment Rights Act, 1996.
He's an expert, by the way, Gary. He actually runs a website that's called, what's it called, Jim?
Section 44.co.uk. Thanks, Ian.
There you go. So
everybody should know about it.
Yeah. So Jim can help me out on this one. So every employer's employee's got a right to refuse work if it's dangerous. Is that correct, Jim?
Yes. In fact, they have a duty to withdraw from unsafe working, and that's under Section 7 of the Health and Safety at Work Act, where it says that all employees have a duty to take reasonable care for their own health and safety. And so you have a duty, and then section 44 is the legal protection you have against recrimination from your employer in the form of dismissal or a change of job or position or whatever, anything that's a detriment. It's pretty much when the EU decided to standardize health and safety legislation across member states, they realized that they were going to be relying to a large extent on employees to speak up if it wasn't safe. And the second thing they realized was that they were going to have to build in protection for employees, because it was, I say, anticipated that employers maybe use force or whatever. So our country put that legislation in section 44 of the Employment Rights Act 1996, and pretty much it is, I would say, the cornerstone of the health and safety legislation, because it is your protection for your right to speak up if things aren't safe at work, your right to withdraw from working and actually remain away from the workplace while the danger remains. So it's extremely powerful legislation that puts safety standards in the workplace directly in the hands of employees, not employers. And that's why employers have seen to it that hardly anyone knows about it. But it's there in black and white. And we talk about conspiracies, and I say, is there a conspiracy to keep people in the dark about section 44? Go and read the website and ask yourself, yeah, could it be anything else, you know?
But
Well, what do you sorry, Trevel, what's your view on that?
Well, no, but part of my post was exactly the point Jim just made at the end there. Exactly that point, isn't it? We're keeping people in the dark in some instances deliberately.
Yes.
Absolutely so. And yeah, of course it's going to take time to change things, sadly longer than we'd like. But it is that balance with, not just we, but many others. Go on, Jim. Sorry, go on.
I was going to say, for example, it said no one can legitimately compel an employee to take a risk.
Well, can I just add to that? And that's exactly where I was going to go, because, part of Ian's point was, and Gary, and forgive me if I get the wording wrong, but this expectation, then, unless I'm missing the point, nobody should be expected to go forward if they think they're going to get assaulted badly. It makes no sense.
That's right.
It makes absolutely no sense whatsoever. But at the same time, to use the analogy, unless you're police, law enforcement, some form of enforcement role, then an ordinary civilian member of personnel communities, forgive me, then to use that broad reference, their duty of care, isn't it, is to try and prevent, resolve, manage a situation. If they can't do that, have an exit strategy to walk away from it safely and effectively, to call enforcement, will go forward safely and effectively to manage the situation. I appreciate that's a strategy, I get that, but that principle shouldn't change.
No.
There are moments when people go forward, and in that moment, they're going to get some form of injury. But the point I'm coming to, in that split-second moment, their mindset is they're going to manage this situation. But to have a fixed moment of, I'm going to get badly assaulted here, then I'm sorry, it makes no sense for that person to go forward. Absolutely no sense in my mind.
But the thing about it, we're in the security industry, and you're working in the social economy, or look at the retail, which happens now with there's so much grief going on. These people are expected to go forward or expected to do something.
Well, expected by who, though, Gary? Sorry, I cut across it, but expected by who?
Well, the thing is, that's a good question, Trevel. And the fact is, you just hit the nail on the head. It's expected by the industry. It's expected we should go forward. But the results are like, if we don't go forward, then we look and lose a job. If we don't do what we're meant to do, the contracts are lost. And
I respect the point.
And this is the thing, you're right what you say. And if you're standing there and you've got a very violent person, and you can't walk away, you've got to stand your ground, or they're going to come in, or they're going to do whatever things, retail, they're coming in, they're taking stuff, and you go, hang on, I'm walking away from this. My job is to look after the premises, the property, and what have you, and I'm going to step away because it's unsafe for me. You've got your legal right for that. We understand that. But what happens? Because the police aren't coming. The police, they made it clear they're not coming. They come for mental health patients now. They are not coming. They're not turning up on your venue. You're lucky if they do turn up. So what is the security officer meant to do? And they've got to stand there and go, well, we stand back. Then the contract's lost for the company. Then they lose their job because they weren't prepared to get involved. You know, where does that person stand?
Yeah, no, and I acknowledge, please, and I acknowledge, you know, and you know, the point we're all making before, isn't it? You know, unless we were doing a specific case study live or hypothetical, then you know we can get into nuts and bolts. So these things are quite generalist until we get on specific points. But you know, Jim made the point before, you know, and I don't know if it was the same case, but in August 21, you know, the paramedic ambulance worker who allegedly assaulted a 14-year-old lad was dismissed, and an industrial tribunal was awarded £49,000 for unfair dismissal, you know, around an alleged assault, you know, themselves. And that's based on the case we're reading, by the way, and I acknowledge that as you do. But the point is, though, isn't it? You know, whilst he was remunerated, and it's not about the remuneration, it's the untold stress and distress it's causing upon that person. Yeah. These factors again, I mean, that's one of the big issues for us, which, you know, Jim's point and all of our points around, you know, the people not being aware about their rights, you know, and their rights to not to refuse. Let's be honest, don't get me wrong, I acknowledge that, but it needs to be evidence. I don't mean, you know, big formal documents, but it needs to be evidence. If somebody refuses to do something, they've got to be able to back it up. Yeah.
I think a lot of it's to do, I think, the conflict between what the law allows you to do and actually gives you a duty to do, not just allows you to do, but gives you a duty to do.
Can you expand on that, if you don't mind, please? Can you just expand by that, by way of example?
Well, everyone has a common law duty of care, not only to themselves, but to others, to prevent a wrong happening. So there's our legal duty there. And then we've got our legal right to self-defense, as you're all aware of. So there's like a balance to be drawn from it. So you've also got a conflict then where an employer's policy would say something like hands off or no contact with the clients. And I remember speaking to a security officer for a London hospital, and he got pretty heavily bashed up, punched 3 times and headbutted, and he hadn't defended himself. And when I said to him, why didn't you defend yourself? And he said, oh, we've got a no contact with the patient's policy here. I didn't want to risk getting sacked. And you think, well, yeah, maybe he made that decision in the moment, but he was not guided well. I'm sure that the trust would never want anything like that. That's like, as you said earlier, with the minimum force ideal. Yes, it's an ideal. It is to guide people towards choosing the least restrictive, least intrusive, least forceful form of intervention. But yeah, there's no doubt about it. There's a big difference between when you go to court with minimal force and reasonable force. And it's interesting, I think, to remember that the CPS guidance is that no one's going to get charged with using unlawful force unless there's evidence of a grossly disproportionate use of force. So that keeps a lot of people safe. The fact that there is that chasm of difference between, yeah, what would be reasonable and what would be totally grossly disproportionate. That would protect most people, I think, from civil proceedings. And I think we have to remember that in some instances there's a public interest in a trial taking place, a proper trial taking place to judge someone's behaviour, especially if the outcome has been fairly serious, even where there's actually no realistic prospect of them being found guilty. There's one in the news right at the moment, isn't there, with an authorised firearms officer of the police. And I think there's this public interest thing about it, but the advice to people should be, or to employees, security employees, should be based on the risk assessment, which is, I know you're my favourite expression, Trevel, but it goes back to a risk assessment of that role. Does it build in the prospect of a confrontation that may become violent, where the person becomes violent towards the employee? And then what instructions do you give to that employee? And I know that across the NHS, they would say to staff, if you feel uncomfortable or unsafe, you withdraw. But the security officers, that's not their book. They don't say that to them.
Well, that's an interesting point. It's
sorry.
just an interesting point. And Gary, perhaps you could give some of your experiences with the acute side of things that you worked on during COVID, I believe. But it's just, what is reasonable force? And of course,
anything you get away with in court.
but that is, yes, and that is, and it's very sad. But when I used to train and do the things, I used to have a thing called, I used to call it the litany. You know, so, and I drew this up after I spoke with a lawyer who defended with someone in a fatality, where it turned out that the guy was wrong, yeah, and the guy who died, but was actually in the wrong. But the whole defense in the end centered around, he was able to show that he had acted in self-defense. And from that, I drew up the litany about the things that you should cover in your, make sure that you are thinking of at all times. And the other thing that sort of touches me on it, that I just want, is what you said, Jim, about when can you use reasonable force? Well, if you're trying to escape the scene of a crime, I believe you can use reasonable force then, can't you, Jim? I mean, but anyway, Gary.
Under section,
sorry.
Well, under the criminal law act,
yeah,
arresting it, yeah, you can use reasonable force to prevent a crime and prevent an offender escaping.
Yeah, I always thought I was a good
reasonable.
one. I did.
Can't define what's reasonable, because it's always going to depend on the circumstances, which are always going to be unique. But there is this reassurance that no one gets charged with unlawful force unless there's evidence of a grossly disproportionate amount of force. A disproportionate is something for the security officers to bear in mind, is the threat of harm that they're trying to prevent. How serious is it? And is the action they intend to take proportionate to that level of harm they're trying to prevent?
Gary, as someone who's worked as a, as you tell me, as a dinosaur,
as a dinosaur,
in Roman times, what did you used to do?
Roman times, it was very different. Now we got away with murder then, Ian, so that's a different ball game. But no, what the point is the difference between self-defense and reasonable force. Obviously, nowadays we've got to step back. We've got to wait to be assaulted before we can think. We shouldn't be, but that's the image that's now being portrayed.
Well,
you do
that's wrong. It doesn't make sense to do that. If you've got to stand and wait for somebody to punch or hit you or hurt you before you can act, then you might not have a chance to respond.
You might not, but this is the thing which is being portrayed in the training now. We've got to stand back. We've got to use PR training. We've got to do our conflict management. That's all well and good, but again, we talk about this.
I think that's probably just the message getting twisted. It is to me, and you must have seen this, is that a lot of security people assert their authority far too quickly, rather than being relaxed about the fact that they have the legal authority and they have a method for persuading this person or that person. But I think that people, a lot of security officers and police, especially police, the way they start behaving is just.
Do you think? Yeah, but this is put down to how people behave towards us. I mean, I know on several points. You can go on, and people still persist and still persist until persist.
Yeah.
A lot of conflict management or conflict or de-escalation techniques, they can take hours. You sit there wasting a lot of time and effort. But we're digressing a little bit here. What the point we're looking at is, the point we're talking about is the fact is self-defense. Can we use our self-defense?
Yeah.
What is reasonable, and the fact is, we also spoke about Section 44. People can walk away from that, and security officers, as we said, are really not expected to walk away. They can do, but then we lose contracts of bits and pieces. Working in a hospital trust, going back to Trevel's post, and me working in the NHS, supposed to have here, is they put a lot of things in play for people. They don't want people to get hurt. They see patients as the priority, whereas they don't put staff as priority. They see the patient has a right, and the staff doesn't have the right. So to defend yourself in that primary role, in that environment, is very, very poor, really, because as you say, your paramedic person, he's now done whatever he needed to do, and he's been chastised for it. But when we look at the security officers, you've got retail security officers, got all these guys flooding from the door, and they can go, "Oh, I'm not going to do that. I don't have to. It's dangerous for me," But at what point the management again, you need to stop these guys, but you've got a hands-off policy. So if you've got a hands-off policy, how are we going to stop them? And if we put our hands on, now we've got a hands-off policy.
Yeah.
That
starts off with them saying, what's the job description, and then where's the risk assessment for what's going to happen for what we expect you to do. If we just expect you to walk around and provide a visible presence, staring hard at people, some people, welcoming others and giving them too much attention so that they leave early. Yeah, that's what it comes down to, is the amount of information they're given on how to behave and respond. Because the bottom line is, you do have a right to defend yourself, and you do have a right to use force to defend yourself, and you do have a right to use it preemptively. So a company policy can't deny you that legal right.
But that's the whole point here, though, isn't it? And exactly, when you said about a no touch, no hands-on policy, but but it's the way the message is being delivered. It's just
that's guidance. Yeah, it is.
Yeah, but that's exactly the point, though, isn't it? But
it can lead to you getting, dismissed, and then you'd have to go to the employment tribunal and show that what you did was reasonable in the circumstances. The employer would have to produce their risk assessment training record where you were told what to do, what to do. If it was left a big open gap like it is in most places, it'd be difficult to say, and any disciplinary process would have to follow legal process. So if the police were involved, was there the use of force reported to the police? Nobody would use the discipline side until the police had finished their investigation, by which time you got it. And at the same time, you can't be dismissed or, have your wages reduced or denied for having taken action on safety grounds to defend yourself.
Well, but surely then, if I've got a no-touch policy, then the last bit you just said, isn't that taking away my basic right to protect myself and/or others?
Well, it's trying to, but this where the two compete. The law must win. The common law must win.
Yeah, absolutely.
But at the same time, let's convert that to a policy of saying they used to have no stop policy unless you've seen them, select it, conceal it, walk past the till and exit the store. Whereas actually the law says as soon as you see them do that, you're nicked, But the company policy, your organisation policy would be don't do it until you've seen all these things. And if you don't see all these things, let them go. And the bottom line is that because the companies don't want the bad PR that goes with incidents of restraint and so on, especially if they go wrong.
Yeah.
Now you get into the heart of the matter, though, aren't you? Organizational reputation.
Yeah. I've got a chip in here because I've got a great tale. Because funnily enough, as you would expect, I used to work as a retail manager. I worked for Tesco's and for Asda and a couple of others. And I once nicked a nicking nun. Yeah, that. So you can imagine, if how we had to do it was really careful. Because obviously this was back sort of 25, 30 years ago. You imagine the reputational damage that would go, would go of wrestling a nun to the ground. That'd be fun. But I also want to sort of bring in the differences. I can remember in one London store that I was working at, where a large supermarket, where what we did is there was a call, call 2000, I think it was, and in 2000 every male member of the staff and management team was expected to rush to the front door and confront, you know, whoever it was. It worked. It worked, but then we were also supported because the police would arrive a lot earlier. They would actually do what they had to do. You would also then also have it followed up by, you know, we would also have it followed up with, you know, with prosecutions that actually mattered. But anyway, I want
that policy would conflict with the Health and Safety at Work Act, which says employers have to give you instructions on how to withdraw from danger and evacuate circumstances. So they could never ask you to go towards that danger unless they trained you to do it. So it's just,
but when you don't know, you don't know.
You get exploited.
Yes. Now, I'm well aware, guys, I'm sorry, but I am what I have learned, we really do need to probably pick a case study. Trevel, I don't know what you think, but I just think you know, I think we're near 30 minutes now, aren't we? Yeah?
31 minutes in, 31 minutes.
So, lads, can we just go through, you know, just give a brief, you know, summary of your particular take on where we've got so far, if we've got anywhere, and you know, is it worth coming back and doing this in a lot more depth but with a case study? I don't know.
Yeah, I think as we were talking before we kind of came on air, so to speak, then yeah, it needs a case study because the point we're all making, it's very broad, isn't it? And it's hard to get to specific points because we're bouncing around, albeit there are things we can take from it. But I think just in kind of summary of myself, some of the things, certainly for me, is that balance between, you know, all plans are perfect. We know that. I know it's a bit of a cliche, but they are. But in that moment, we want to empower people, don't we, to do the right thing. So whether that in no particular order is to exit, contain, or move forward, you know, then as we know, only that person or persons in that moment will decide what the best answer is to that.
Jim?
Well, I think one of the first things we should say is that it is lawful to use force to defend yourself if you're attacked in the workplace, even if you have a no contact policy. And if you've acted reasonably and proportionately in the circumstances, you should be safe from any kind of recrimination or dismissal by the employer.
Gary?
I've just got to say, Jim's hit the nail on the head, so is Trevel. It's very open. I'd like to come back and do this more detailed because I'd like to go into section 44 more and just hit that sweet spot a little bit more.
It's power.
Yeah.
It's a huge power.
Let's go.
It's frightening, really. I mean, I tried to find out why no one knew about section 44, and I contacted the health and safety executive, and they said, oh, it's employment rights legislation. And I said, well, hold on, the chapter is headed health and safety cases, and it's legislation that would only ever be invoked in health and safety matters. They said, yes, but it is, we hear what you say. If you recognize that expression, we hear what you say. But it is outside our jurisdiction to tell people about it because it's employment rights legislation, not health and safety. Now, I went to the British Safety Council and said, you teach the most occupational safety, health and safety training in the country and around the world. Do you tell people about section 44? No. What is it? IOSH? Is it in their training? No. And then you start to say to yourself, is there a conspiracy here to keep people in the dark? And it's a very, very subtle thing that they do, yeah. Disappointing, but if everybody knew about it, there wouldn't be any unsafe workplaces.
Well, yeah, because nobody'd be there, Jim. That's the problem. Is you know, and that is exactly why they don't want to tell that they don't. And I'm not without.
Oh, you've sussed it here.
Yeah, right, exactly. Unfortunately, because nothing could get done. the key for guys, first of all, thank you very much for, I know it was short notice. I know we probably should have done it. It's a little bit better, and maybe, you know, as I say, a case study, if we can try and get back together in, you know, a month or so, find a time, that would be brilliant, and really flesh this out. I got so much from this. I know other people did as well. We've got to make people realize that they do have the right to defend themselves. It's not just, it's as anybody, it is a common law right to do that. And we cannot be prevented by policies from taking such action that we believe is necessary to defend ourselves, even if that is to run away, you know, as far as I'm concerned. The other thing that I've really taken away from this, you know, is section 44, the potential power of it, because I believe that it's unlimited compensation, isn't it? That one, if you think. But Jim, please tell us, what is your podcast and your website address so that people can look at it?
The section 44 is the word section, SECTION, then 44.co.uk.
Yeah, that's brilliant.
I used to just say section 44 and you'll find it, but actually section 44 is the power to stop and search under the terrorism prevention legislation.
Yeah.
So, was that a conspiracy to keep that? No,
I don't know. We will find out.
Just a
We'll have to
coincidence.
pass this over to Elon Musk, because apparently he likes all of that kind of stuff. So we'll be happy. Guys, so grateful for this, you know, very short thing. I hope you've got as much out of it as I have. And yeah, peace out. See you later, guys.
Cheers, guys.